Step number 6 is close the probate. I just mentioned how easy it is in Idaho to close a probate. You don't even need to do anything. You just kind of walk away from it. In Washington, what is done in Washington is the personal representative completes a pleading that's called a declaration of completion. And that just tells the court, hey, I'm done doing my job. Everything's been done. And so now, court, you can close the probate. So that is called a declaration of completion. And typically when we do that, we file that with another declaration that the personal representative signs that says that they did their job, making sure there were no creditors, and if they were, they were paid. We typically file it with the receipts from all the beneficiaries. But for do-it-yourself probate, what you just need to keep in mind is a declaration of completion is the pleading form that you would then file with the court, and then that is what brings the probate to a close. There is this process, again, do-it-yourself probate is anticipating that you're not having problems, you're not having it really complicated, that you got everybody to sign a receipt form that says, hey, they got their share. If you don't get those receipts and you file your declaration of completion, you have to give notice to people who are the beneficiaries of the estate that you're doing that. They have a 30-day time frame to file an objection with the court to say, hey, no, the personal representative didn't do their job right. So again, if you're dealing with that kind of formal process, 30-day notice period for objection, that doesn't lend itself well to a do-it-yourself probate. So that's how you close up a probate and go through the 6-step essential process. And I'm just going to go over that really quickly again, which was step 1, open the probate. Step 2, notify interested persons and agencies of the probate. Step 3, gather up all the assets. Step 4, evaluate pay creditors' claims, make sure taxes are paid. 5 is distribute out the assets, and 6 is file the declaration and close the probate. Question I have here is, how is an estate closed that did not go through probate? It's a really good question, because lots of times estates don't go through probate, particularly if you're talking about spouses, 2 married persons. They often don't do a probate on the death of the first one because they don't need to. They might have signed a community property agreement that says everything we have is community. So everything goes by way of joint titling or beneficiary direction. Both of their names are on the house. There is not a need for probate oftentimes when the first spouse dies. So maybe there wasn't a probate on the death of the first spouse. When it comes to estate planning, that may be the right way to go. It may be the wrong way to go, but that's not what we're talking about. There oftentimes is no probate on the death of the first spouse. Well, what if there's a single person that dies? And what if there is no probate? Again, at some point, if somebody wants to get the assets, there's going to have to be some sort of estate administrative process to get those assets. The period for a probate typically runs 4 to 6 months. And why I say that is there's that 4-month creditors period. And so let's say the personal representative does everything, just, they're on top of it. Usually you close out within 6 months. During that 6 months, you can sell the house. There's all sorts of things that you can be done. You're not just waiting for that 4-month creditor claim process and doing nothing. The PR, personal representative, is doing their job. But let's say it's been a year, the person has died, nobody has done anything, or maybe it's been 2 years. You can still open up a probate 1 or 2 years or 3 years after a person has died. But the probate can be opened when somebody realizes, hey, something should have been done. There is an estate administration that should have been done. The longer you go out, I think it just makes it more difficult, because what happened to that asset during that time frame? The bank maybe has paid it to the state fund of unclaimed accounts. You may have heard of the term escheat to the state. Not quite sure if I said that right, because we rarely use that term, but what that means is, hey, if nobody claims anything, it goes to this, the state where they keep all these assets. And you can even look online, unclaimed funds for the state and see if you have any. We did that recently, and one of our paralegals found that there was $70 waiting there for her. So probates are typically done within the first 1 or 2 months, but sometimes it goes on. People don't realize of a need until 1, 2 years or even more. Okay, so this is an estate planning question, and the question is, let's say there's a couple, it's a blended family, and maybe the will says everything goes to the surviving spouse. What's going to happen with the children who may have been the children of the deceased spouse who are not the children of the surviving spouse? This is a really, really important part of estate planning. Oftentimes what we do is we set up trusts so that the deceased spouse's children will inherit. Sometimes families don't do that. And depending on what the will says and how things went with the probate, it could be that the children of the first spouse to die are effectively disinherited. They end up getting nothing. And that could be because that was the intent, or it could be because that was just poor planning. So getting good estate planning in place is the best way to make sure that there is not an unintentional disinheritance of the children. Thanks for hanging in with me so long, guys. I'll keep answering questions as long as people are posing them. So, for those people who said, hey, I only had 45 minutes, if you want this probate checklist, let me share it with you for those of you who can see it, and then I'll come back to questions. So just email us, webinar@elgwa.com. We'll send you this probate checklist. You might be able to see it on my screen. It's, the same sort of steps we went through, just a little bit more detail than what we talked about in this checklist form. But send us an email at webinar@elgwa.com, and we'll send this checklist to you. For those who are interested in learning more than what we're able to cover, feel free to call us at 509-468-0551 or go to our website, elgwa.com. If you have participated in this webinar and you're listening to me now, and what I want you to know is our firm, let's say you've decided, do-it-yourself probate, I've tried it, or I don't even want to try it, I'm overwhelmed. We typically do charge a consultation fee of $375, but if you call us and say, hey, I just listened, Lynn was talking about do-it-yourself probate, we'll offer for you a complimentary consultation. Just come in, you'll speak with one of the lawyers, we'll do that complimentary for you. That's kind of one of the benefits of staying with me to the end here is give us a call, we'll give you a complimentary probate consultation. It's going to be within certain parameters though. If you call and say, hey, my brother is doing this wrong, he's a PR, I'm going to sue him, that's not going to be something we can help you with. Part of what we do at ELG Estate Planning is setting up the estate plan so that there are not problems. I used to do litigation. Over 20 years, I was a litigator. And when I pivoted my practice to doing estate planning and elder law, one of the reasons I did that is I wanted to help people proactively make things, set up a good plan, not fight. And so I had 20 years of fighting as a litigator. We don't do that anymore at ELG Estate Planning. That's just not part of our practice. So if there is a situation where you need to be represented because it's a probate gone bad, we'll refer you to litigators. That's just not our practice area. So the email, and you'll see it in the chat, it's webinar@elgwa.com. All right, so let me get back to a few questions for those that I haven't yet answered. Is who are the heirs at law? I love that question because it's the statutory scheme. So I'm going to go through who the heirs at law are. So let's say you are married and it's a blended family and you have 3 kids from a prior marriage and you die. Your heirs at law are your spouse and your 3 kids. Your heirs at law do not include your spouse's kids, your stepkids. Those are not your heirs at law. So heirs at law are spouse and kids. Let's say you don't have a spouse. Heirs at law are your kids. Let's say you had 3 kids, but one of them didn't survive. Then your heirs at law are your 2 surviving kids and any grandchildren from your deceased child. Let's say you don't have kids. You're single. Who are your heirs at law? Then you look up. They are your parents. Let's say your parents aren't alive anymore. Then your heirs at law are your siblings, brothers and sisters. Let's say you have a deceased sibling. Then the niece or nephew of that deceased sibling stand in the position of that deceased sibling as an heir at law. So it's this statutory scheme where you go down, you go up, you go out. So heirs at law are, as I say, it's statutory. If it's an heirs at law question, I'm sure you could Google research, RCWs, that's the Revised Code of Washington, heirs at law. But if that's your situation, you might want to just check with an attorney as well. Thank you so much for the compliment from one of the listeners about the importance of doing an estate plan, and that basically glad that they had our office do it. I really appreciate that. Thank you so much. Again, if you have any questions, feel free to reach out to us. Our phone number is 509-468-0551. That's 509-468-0551. And you can reach out to us at webinar@elgwa.com. Feel free, if you have other things that you want to learn about, have me talk about, just send that to us, because I love doing these educational events where I can help share information. Even if you've had an estate plan done by us or by somebody else, sometimes it's just hard to understand exactly how things work. And so happy to answer your questions and do more of these presentations. Again, thank you all who joined me today, and I'll be signing off. Thank you.